everyone, and welcome to January and 2025, the first compliance corner in a new year. And as with others, we will have updates for you on hot topics since our previous compliance corner in December. And items marked with an asterisk will include a link below, so make sure to take note of that. As Heather and I are going through the slides, we have compiled additional materials for you to help dig in a little further on those topics that might interest you, and those links can be found in the description of the video. So for January, we have a few things to cover, and here's a summary of what we'll be going over. Of course, we're just into the new administration here, the new presidential administration, and many have likely seen that there have been a few executive orders. And so we did want to just take a moment in this video to look at them from a high level here. There are quite a few, but give you something to take back to help you understand the process and the potential impact. As Heather will discuss, there will likely be more developments to cover in the future, and given the implications on the rulemaking process, we'll of course have to follow that as we go through working with this new administration. And the agencies are working through those proposals and rules that they've been working on, and of course their priorities. We also have some state items, including a new DFI secretary and winding up for the start of the legislative session. And we'll cover that in its own slide, as well as a quick mention as well. We just looped in some federal items, the civil monetary penalty adjustments for inflation. And then that will flow into an update on the BOI reporting rule, which we continue to have updates and news on, a few different CFPB specific updates, and FTC finalizing changes to the COPPA rule, which will, of course, need to be considered as well in light of the new executive orders, which I will hand it over to Heather to discuss now.
Super. Thank you, Scott. And again, Happy New Year to everyone. We look forward to what 2025 will bring for all of us in the compliance regulatory world. And as Scott mentioned, it's been a busy first part of our year with a number of executive orders that have been issued since January 20th. For more information on those specifically, feel free to reach out to Scott and myself. We are tracking those. But as Scott mentioned, we wanted to make sure that there were a couple particular items of those executive orders kind of on your short list as it relates to compliance and what you may have on your plate back at the office. And one of those being the regulatory freeze pending review order. This is something that happens often when administrations change. This happened back in 2021 when we had the administration new at that point. But what that does is it allows for new department agency heads coming into the role to further understand what rule is going to be proposed or what rule was recently proposed, or even guidance for that matter, to first get their head around it, to get their arms around it, so to speak, and review that to really determine whether or not that's the particular process or method that the agency is intending to go down. So there is normally a pause. And that pause then for, in this case, 60 days, gives a timetable for us to kind of wait and see what might remain effective, or whether or not we're going to see issuances by the agencies asking for more comment, where they reopen comment periods. Potentially, they might issue a whole new rule. So time will tell as we work through these next 60 days, but it is an important component, a little bit of a pause for us as an agency to kind of wait and see what we can expect going forward. Another important order was the appointment of several key figures for our agencies, including the acting chairperson of FDIC. And we have seen postings for SBA, for SEC, for the CFTC. So a number of different agencies are going through all those appointments and chairs right now. And again, that's important because it gives us a little bit of direction and priorities as we work with those agencies. The third executive order that we wanted to make sure that you were aware of was involving digital assets. And the intention here being clarity around that term. There are some definitions embedded within that order, but it's looking to include cryptocurrency, digital tokens, stable coins. And that order also looks at artificial intelligence. So within that order, agencies named are to identify rules, guidance, etc., that touch these particular areas and provide a list to a committee and provide recommendations as to whether or not some of these ideas or rules should go forward or be revised, etc. So we'll go through the rulemaking process at that point, but at this time, there's a pause on those particular industries as well as we look through what that committee will be doing. So you'll be seeing again much more information on this as we go through the next 60 days. And if you have specific questions, please don't hesitate. Scott and I would be happy to do research if we need further, if we don't know it off the top of our head. I will say that we've already fielded questions about what does this pause do with respect to Section 1071 and the CRA rule, which is both of those are both in current litigation. And with respect to those two areas of big law, that is not something that is paused by this regulatory freeze order. Both of those areas of law were something that were effective much earlier than the recent 60 days prior to the order. So those are still in motion. Those are still going through the litigation efforts. We may separately see agencies take action with respect to those two rules, but this pause does not stop either Section 1071 or the CRA rule that we are waiting for further action on. So with that, I'm going to turn it back to Scott to take us through our state level items.
Yeah, thanks, Heather. And speaking of key figures on the state level, you may have already heard that DFI Secretary Cheryll Olson-Collins will be retiring as of February 3rd of this year. It's been a pleasure working with Cheryll throughout the years. We've had a close working relationship with her, both during her time as deputy secretary, among other roles, and of course as secretary. And we wish her well in her retirement. There's a link, again, in the description below where you can find the press release that comes from the governor's office. That outlines all of the many accomplishments that Cheryll worked through and was able to accomplish throughout her tenure. The governor has also announced that he will be appointing Wendy Baumann as Cheryl's successor as the new secretary of DFI. The release then discusses that appointment a little bit more, including some additional information about Wendy. And Wendy will be starting as the new secretary effective February 17th. In addition to that, the governor also delivered his address for the 2025-2027 biennial budget. The process also includes major request items from the state agencies, and that is included within a link below. If you do open that, don't be overwhelmed by the 263 pages. That's just part of the budget process. We've gone through it before. It's always like that. There's always quite a bit to look through that. And we'll, of course, be reviewing that and the budget closely as we have in the past. The governor's budget then is expected early sometime in February. So we are moving quickly into that process. Lastly, as we transition into some federal items, just wanted to loop in a quick mention here of federal civil monetary penalty adjustments. So FinCEN, FDIC, OCC, and the Fed have all adjusted their CMPs for inflation, as they have done in the past. This is standard, typical process. We wanted to include this for mention as well, as we do when the agencies always adjust their thresholds, but also make a mention to note that this is subject to existing law. This is subject to existing process whereby this adjusts automatically and the agencies have authority to do this. So it's not subject to any stay or any pause by executive orders, similar to what Heather had mentioned on the previous slide. With that, I will hand it back off to Heather.
Thanks, Scott. I'll just also add that if you're looking for a particular civil money penalty number and what a particular agency has adjusted that threshold to, check out the regulatory spotlight section of the WBA Compliance Journal. We do include that in what we report on each month. And the agencies, when they issue those updates, do so in about a 4-month window of time. So going back to November, even through to what will be in February's compliance journal, you'll be able to find those links should you want those for your particular agency. We also wanted to mention, as Scott alluded to in our opening, that we have the hot potato, and the hot potato being FinCEN's Beneficial Owner Information Reporting Rule, as it bounces back and forth between is it effective, is it not effective, is it effective? Well, it is not effective right now. So we have a court process that is working through all those various stages, and we have a stay right now, a national stay, so that our business customers are right now not required to report their beneficial ownership information with FinCEN underneath the rule, as the Supreme Court takes a look at the Corporate Transparency Act and whether or not FinCEN had the authority to promulgate the rule as it had when it made that requirement in the first place. Having said that, though, I will say that we still feel questions about what do we as bankers need to do about our bank's customers reporting beneficial ownership information. And our recommendation is nothing with respect to what the bank customer has to do. So we include this information, and we've included the link to the most recent alert on FinCEN's page so that you, when you're working with your customers, have that knowledge in your back pocket, that you yourself know what the current status of that reporting requirement is for your business customer. The rule is very clear that that reporting requirement and the knowledge of the reporting requirement is something that is on the shoulders of your business customer. They should be following that, and they should know through their own expert resources what they need to do as their own self. They can voluntarily report if they want to, but we just want to make sure that those of you working with your business customers understand what the status of that rule is. In addition, though, the BSA requirement for banks, we are still 100% required to collect our beneficial ownership information from our business customers under existing BSA rules. And so you're going to continue to take those steps as your frontline staff need to when first working with those business customers, et cetera. But just know that the businesses reporting themselves have been paused. But don't let your foot up off the gas pedal, so to speak, with your own BSA requirements underneath your own reporting and collection. So with that, Scott, back to yourself.
Yeah, so just a few CFPB items to cover here. So first is a supervisory highlight, which CFPB released recently, discussing some observations that the agency has gathered from examinations it's picked out from institutions that are using credit scoring models. And of course, we're talking about a focus on those that are now built with new technologies, right? So artificial intelligence, other machine learning, those that can kind of adapt and grow and learn, and CFPB continuing to keep an eye on that, right? Largely seeing the implications from a potential discriminatory impact. So this has been and continues to be and will likely continue to be a comprehensive undertaking by CFPB in their exploration of that in not just discrimination, but consumer protection laws and the agency's overall goals as a whole. Again, the impact of these new technologies. But in this specific supervisory highlight, CFPB is looking closely at credit scoring models and how they comply with ECOA and fair lending, and of course, they're implementing regulations. More specifically here, CFPB has looked at credit card lenders and their use of complex credit scoring models within the underwriting and pricing of applications, essentially looking to spot where there might be disparities or discriminatory outcomes that might be a result of a prohibited basis due to these technologies and kind of how they function. And similar to that, CFPB has also looked, and you'll find it within the highlights, at auto lenders models for review and adverse action notice procedures for auto lenders. Now, one thing to note, even though we're talking credit card, we're talking auto lender, as other financial institutions, as banks start to explore and use this, it's important to understand these implications, right? And see how CFPB is viewing this and take from that the lessons that are learned and understand how to use them and understand the implications so that banks and those who are just starting to use these models can then approach them appropriately with these potential issues in mind. Another thing to note is that CFPB in this highlight isn't necessarily taking a stance that such complex models, AI or machine learning, is prohibited. In fact, it's more observational. CFPB is identifying potential faulty points, potential issues, where usage of this could potentially run afoul and result in a discriminatory impact. And so as part of that, CFPB is again, observing, identifying, and proposing potential alternative, less discriminatory models, ways to use this in ways that don't run afoul of those and don't have discriminatory result. So again, when using or exploring these types of technologies, the key is to be aware of the potential unique considerations that they present when you're evaluating and using them, while being aware of potential disparate impact or other discriminatory results. So again, this highlight, it's not too long and it does have value in that sense. The next item, now with this, it's nothing new, no new guidance or no new rules or regulation, but rather a helpful resource compiling guidance documents that CFPB has issued through November of 2021 and December of 2024. There's certainly been a lot, and oftentimes it can be difficult to pinpoint what you might have in your mind's eye when you read something, when you were researching a particular issue and you knew that CFPB had a guidance or had said something on a particular topic, and you're just trying to find that. So having it now in one place is quite helpful. There's a table of contents as well with links to help you find what you're looking for. So make sure to take a look at that document, which is included in the link in the description below as well. The last CFPB item we have here is a withdrawal of its proposed rule to prohibit charging of certain NSF fees. So the proposal here would have prohibited covered financial institutions from charging NSF fees when consumers initiate payment transactions that are instantaneously declined or near instantaneously declined. So this might be like, wait a minute, a little bit of deja vu for those of you who are hearing this. And that's because this rule was originally proposed a year ago in January. So we're just about on the anniversary of when we would have been talking about the proposal of this rule. And WBA did comment on this proposal. Among other commentators, did recommend that CFPB withdraw the rule. The concern being that CFPB is taking an approach that is far too broad in application to an issue that it hasn't fully identified. And so the result wasn't going to be intentional, wasn't going to follow with what CFPB actually wanted to accomplish with the rule, and was actually going to result in harm in these products that banks offer to their consumers. So in light of the comments that CFPB received, it is withdrawing the proposal, due again in short to it covering fees that it was largely not intended to cover. That said, CFPB is going to continue to consider whether there's a different way to issue this rule. So again, we will see what CFPB's priorities are under the new administration, but we know that this is still a topic, still a priority for the agency as a whole. And with CFPB wrapped up, I will hand it back off to Heather to bring us home.
Thanks, Scott. So we did want to make sure that you had awareness of a final rule issued by the Federal Trade Commission. It's a final COPPA rule. We've had COPPA before, so this is the Children's Online Privacy Protection Act. It's a rule that has not been touched since 2013. So as you can imagine, with the internet use changing over that period of time, it was worth taking a look at to see whether or not the rule needed to be updated. And that is something that certainly FTC took some time to do. And what we have here is a high-level list of the changes that have been made by this rule, where we have new requirements on the collection, on the use, and the disclosures that are being used for children's personal information. So now we are going to have a more specific requirement for operators that are collecting this information to share who they are collecting the information and sharing with, and the categories of those third parties that the information is being shared with, and more specific about what is the use of the information collected, as well as more specific instructions for how to protect against misuse of the information that has been collected. There are a host of revised or beefed up disclosures that will be required underneath this revised rule. We have a direct notice requirement that needs to be given to parents prior to collecting and using the children's information. We have a separate online privacy notice that has prescribed language that need be provided at a relevant time and easy to identify. We also then have a verifiable parental consent. Now, that's something that's a carryover from the original rule, but there has been additional methods added to that component for how we are verifying parental consent. There is a parental opt-in to advertising that needs to have its own separate disclosure and, again, consent. There are new limitations on data retention. So this is putting forth when an operator has collected children's personal information, the time period for which that information can be retained now may be more narrow in scope than what was previously retained. There is no longer this unlimited time period. We need to narrow that down to the reasonable time period for which it was collected and then used versus this theory of indefinitely using it for a possible what if down the road. That new limitation on data retention also requires that the operator has to adopt a written record retention policy of when they're going to retain that and otherwise dispose of that children's personal information. We also have a refined definition of personal information. Again, as time has changed from 2013, we have new indicators such as biometric information of children. So the rule does look to identify that term more broadly now to identify information that's collected beyond just that of a social security number of a child. So when the rule was issued, it has an effective date of 60 days after published in the Federal Register. It was only just recently published. As Scott had mentioned when we had started with our conversation during this video, that this would be one of those rules that is subject to the executive order of pause. So we will see whether or not the rule stands as it is, or potentially whether or not there will be an open period of additional comments that can be added, and whether or not there'll be a revision to what we have just seen as an updated COPPA rule. This is one of those areas of law that you're going to want to at least put a flag in your policy if you have a COPPA policy because of your advertising and outreach to certainly keep an eye on, because there will be some updates that you likely may need to do to your policy if in fact this rule is applicable to you. So depending upon when we get the final rule, if this gets passed on and approved and we have a new rule, there's a 1-year implementation date as it stands right now. So a little bit of a stay tuned, but certainly something that you're going to want to keep your eye on. This is one of those rules that would be, again, reported upon in the regulatory spotlight section of the compliance journal. So we will certainly have it included there, as well as then a larger article about the more particulars of the rule, if in fact we have a green light and this rule stands as it is. But this rule, as you might remember, has some significant civil money penalties assessed to it. So it is something that you do want to keep on your radar, at least now, and then we can go forward with what might be final after the executive orders, etc. So that is our lineup of what we had for you that's been issued here in these last few weeks of January. We certainly always want to close with reminding all of you of the resources that WBA always has available for you. We've been very busy on some new guides and updated reference charts, so be sure to check out all of that information within our compliance tab resources on our website. compliance journal just went out, so make sure you get that read top to bottom here before the month closes. We also have our hotline that you're always able to give us a call anytime. Our in-house training, please don't forget about that exciting opportunity where we can fine-tune compliance training to your specific needs. Scott has been very successful with that here this year, offering great information fine-tuned to the bank's specific topic and need, and works very closely then with your training and experts there at the bank to make sure that the legal part of it and the procedure parts are merged together quite well. Also, you may have seen in the daily, we've got an upcoming Legal Live that Scott is preparing for. So that is February 11th. So make sure you've got yourself registered for that so that you can hear all of his wisdom as we walk through another very helpful resource for our membership. We also want to make sure that where you can, get involved. We're always welcoming bankers to our committees and our sections. We'll be launching that here in March, collecting new names for committees. We have a whole host of different committees that we welcome new volunteers and enthusiasm. And certainly don't forget to be an advocate for your banking industry. Scott and myself work very closely with our government relations team, and it's such an important component for all of us that are dealing with rules and regulations that you have a voice, and an important voice to explain your concerns and your burdens and your recommendations for smart regulation as we work through the industry that we do. So certainly don't be shy. Scott and I are always happy to help you through your troubles of the day. So feel free to give us a call and we'll be happy to help with that. And we look forward to seeing you all at Compliance Forum also in February. And if not there, then next month's video. Take care, everyone.